Respected seniors, dear members of the bar, good afternoon to all. Today, we have a lecture on GST on a bird's eye view. Earlier, this very same topic had been well explained by Mr. Vaidishwaran just 3 years back. Now, Mr.G.Natarajan, tax practitioner from Swami Associates, he has given many lectures in the Revenue Bar Association and other associations. His great expertise in this field. He will clear all the doubts about the GST. Particularly, we want two aspects. One is applicability of GST to the advocates, individual advocates. Second, what is the impact on the advocates firm? Advocates firm, whether it's included, it is under the purview of the GST. Mr. Natarajan will explain all these things. I invite, on behalf of the Madras Bar Association, I invite Mr. Natarajan to deliver this topic. Very good afternoon to all of you. First of all, my deepest gratitude for giving me this opportunity to address this august body, which is a dream come true for any advocate who is practicing in the Madras High Court, and I especially thank Hemlata Madam for giving this opportunity. The topic is GST, a bird's eye view, and we have the time constraint. Maybe we have to close by around 2:15 or 2:20 before the benches start commencing. For such a vast topic, having some 25 to 30 minutes will be a disservice, but still, whatever is possible we will try to do. And really, at the end of the session, you will have to tell me, this bird's eye view, am I going to be like a majestic falcon, taking all of you to a height to have a panoramic view of the entire GST law? That is going to be your experience. Or as a bunch of crows sitting and eating all the food, whatever is there, for 5-10 minutes without any use, how it is going to be this session, you have to tell me at the end of the session, because time constraint is the one biggest factor which we have to worry. So as we all know, I don't want to repeat whatever we have been hearing about GST, because now, after GST has come, when there was excise duty, no public will know about excise duty. If you say excise duty, another excise duty on. So like that, people will not know. Service tax also was not known to the public that much. Even though compared to excise duty, the awareness was little more. But today, everybody knows GST, everybody wants to know GST, and everybody thinks that they know GST. This is the reality today. But what is there in it really? What are all the problems in it? What are all the ways and means to overcome those problems? So as a citizen, more so as an advocate, we should be able to know that what is the entire background. So, any successful marriage is full of compromises. Unless we compromise, the marriage will not be successful. So similarly, GST is also an experience where all the stakeholders have done lot of compromises. It is that compromise which is going to decide whether this GST is going to be successful or not. All the people have done their sacrifices, all the people have compromised. For example, central government, if you take, they are committed, every year I will give you 14% extra. Whether our economy is growing at 14% or not, because of COVID we suffered minus growth. Despite that, the central government has assured, I will give you 14% incremental compensation every year. There are some practical issues on it, we will not come to that, but there is a commitment from the center. The states, they have surrendered their legislative power. Today, whatever notifications, whatever is decided in the GST Council, automatically the state governments have to issue notification. We all practitioners who are in the taxation field will know, once there is a central notification, we will not even bother to check whether the state has issued or not. We presume that the state would have issued. because the organized manner, all the central notifications are available in the site, whereas different states, the updation is not very proper. So most of the people, unless those who are from the VAT background, we don't even check whether the state government has issued the notification. We presume that they would have issued the notification. So to that extent, they have surrendered their legislative right. That is a compromise from the state side. They also gain. Till now the states cannot levy any service tax. Till 2017. Now they are reaching up to service tax. This is a gain for the state government. The central government earlier, they cannot go beyond the manufacturing stage. The excise duty will stop at the factory. After that, dealer, wholesale, retail, the central government will not come. But now the central government can reach up to the roadside retail shop. So they have gained. And what we the practitioners, we have given lot of sacrifices. We lost many sleeps. In understanding this complex law, so many sleepless nights we have to spend, and that is our compromise. And all of us have been benefited by this law also. So it is for good in the longer run. There may be problems. Day to day there will be lot of complaints, technical glitches, not able to file the return. There is no proper mechanism available. My vehicle is stopped. These are all there. But that is bound to be there. These are all our professional hazards. If problems like that are not there when such a law is introduced, then we don't have any business or relevance. So problems are there. We are all there to take care of the problems and solve the problems. Judiciary is there to knock at the doors whenever it is required. So we can't just imagine that once GST comes, all our problems will be solved. Like in one Tamil movie, he will have all the health problem and he want one tablet for all those things. GST is not the solution for all the problems, but in the longer run, it will definitely be good. But still, we have lot of issues, lot of things are ailing the GST today. So from a common man's perspective, so what are all the major issues which is engaging our attention? I will try to cover in the next 15-20 minutes, and finally I will address what the President told also against the advocates levy also. First of all, before I start, I will just read one sentence from the Constitutional Amendment Bill, the statement of objects and reasons. When the Constitutional Amendment was introduced, this is what is said. GST is intended to remove cascading effect of taxes and provide a common national market for goods and services. The tax on tax, like that, excise duty was there. VAT is leviable including excise duty. So like that, lot of cascading effects were there. And this is from the statement of objects and reasons. When the GST bill was introduced, the CGST bill was introduced, they said the present tax system on goods and services is facing certain difficulties. There is cascading of taxes, as taxes levied by the central government are not available as set off against the taxes being levied by the state government. Certain taxes levied by the state government are not allowed for set off. Due to the seamless transfer of input tax credit from one stage to another in the chain of value addition, there is an inbuilt mechanism in the design of GST that would incentivize tax compliance. Because this ITC benefit is not any large is given by the government. It is not something which the government wants to extend a benefit and give you. But this ITC is the core of GST. The entire GST architecture is built on the concept of ITC. So what is ITC? I sell something to another person, I pay GST, he takes credit, again he sells it again, so he will pay GST. So like that, this is a destination-based consumption tax. We are aware of this particular phrase, which means ultimately the tax burden will be on the consumer. Till such time everybody is only a pass-through, and ultimately the consumer will bear the burden. So how to achieve this? There are two ways to achieve this. One way is, government can say, we will put GST only on the last leg of the transaction. We will not put tax on the manufacturer, no tax on the wholesale dealer, no sale on anybody. Finally, the consumer is going to a small shop and buying. There alone we will put GST. So then the burden will be passed on to the consumer. But that is very, very difficult in a country like ours, where it will be prone to various evasion. Unorganized sector is there. At the retail level, it is highly unorganized. So the government cannot implement that levy. So that is one way of doing it. Maybe a small countries can do that, but India cannot afford to say that I will tax only the last person just before the consumer. That will not work out. So we have adopted a value added model. So the value added model means I sell for 100 rupees, I pay 18 rupees GST. I sell to sir, he adds some value, he is again selling it at 150 rupees, he has to again pay tax on 150 rupees at the rate of 18%, but he will be allowed to set off whatever I have charged. This is the fundamental principle of GST, ITC. If that is the case, there should not be any restriction on ITC whatsoever. That is the ideal situation. So suppose I want the 18 rupees credit, I have to spend 118 rupees. I have to spend 118 rupees and buy something, so then only I will get 18 rupees credit. Will anybody spend 118 rupees to gain only 18 rupees unless it is very essential for the business? Most probably not. So ideally we should move towards no restrictions on ITC. Thus still there are a lot of issues, still we have not reached that particular level. So we have a lot of restrictions. Construction credit cannot be taken. Why? It's a hangover from the past. Construction, it will involve huge expenditure. If you give credit, they will not pay tax in cash, maybe for 1 year or 2 years. So we will not give it. Motor vehicle we will not give credit. Why? It may be used for personal purpose. So like that, still we have the hangover of the past, but this ITC forms the fulcrum of GST. But unfortunately, what is happening today is this fundamental principle that ITC should be the basis of GST is slowly being diluted. I can say that the government is somewhat in a panic mode because of the frauds which is happening. Day in and day out we are seeing in paper fake invoice, 100 crore. A small person aged 25 years opened 100 companies, passed on 400 crore credit. Can you imagine? So because of that, there is a panic, it seems to be there is a panic in the government which is affecting the GST architecture. But my point is, this panic reaction will not work out. This fake invoice is not something new which has come today or yesterday or in 2017. It's an age-old profession. There are people who will always float the system, but the law should be framed keeping the honest person in mind. The law should help the honest person, and if there is anybody evading, he should be dealt with separately. But unfortunately, the approach which is being followed today is the law itself is framed for the fraudsters. So because of that, majority of the genuine taxpayers are also affected in various ways. So how this ITC was envisaged when GST came? I will give an income tax example. Earlier and all, TDS, clients will deduct TDS. It will not come to our books. There will be lot of mismatch and all from 10 years, 15 years back. Now it is seamless. Almost 99.9% client pays TDS. It is reflecting in our form 26 years. We adjust it and we pay the remaining tax. That is the accuracy which is expected in GST also. If I sell something, I raise an invoice, it should automatically come to the buyer's books. That is what the intention of GST when it was introduced. There was a section 41, 42, 43. So how they planned it? I am a seller, I raise an invoice. I upload my invoice in the GST portal, day-to-day basis or monthly basis. Once I upload that invoice, my buyer will get the details. Like form 26 AS, it will reflect in the buyer's records. He will verify whether everything is correct, or if the supplier puts, I have not purchased anything from A, but A has put my number, so I will get the credit wrongly. I actually purchased from A. Instead of putting my number, he put some other number. I will not get the credit. So I have to verify my portal, check each and every entry. Whichever is correct, I have to accept. If there is any missing, I have to add. If there is any mistake, I have to inform the supplier. Everything through the portal. This was originally planned. So I will verify and file another return. Whatever return I file, it will go back to the supplier. Everything through the system. And he will verify, oh, I committed a mistake. Instead of putting somebody's name, I put Natarajan's name. I will correct it. Like that, everything was meant to be operated technologically. If it was 100% foolproof, we all would have been happy. But it could not be achieved due to various reasons. Because income tax, the number of transactions are very less. Here, crores and crores of transactions are happening in the country. Lot of complications, advance payment, return, debit note, credit note. So many factors are involved. So they just dropped that idea. After 3-4 years, last budget, February budget, they have omitted section 41, section 42, section 43. So this automatic matching is not going to happen in the near future. So it is going to be manual. One, if it is going to be manual, there will always be fraudsters to say the system. So how are we going to deal with it? If you see how the procedures have been evolved over the period, new restrictions, see alias and all, in fact I worked in the department for around 10 years. At that time, whenever there was February month, the government has to achieve the target. So we should not allow the assessee to use the credit. They should pay in cash. So what we will do, even I have done it as per the instructions of my superiors. Go to the unit, take their credit ledger and come back. Those days there will be a register called RG23A Part 2. If you take that register, they cannot use the credit at all. So physically we will take it to our office. Till March we will not give it back. So we are slowly going back to that system. That system has ended long back. In the 90s it was over. But we are going back to that system. How the officers are given the online power to block my credit. An officer who is sitting in the office, he can open my portal and block my register. Are we going back to the era of 20 years back or 30 years back? So this is the panic reaction with which the government is moving today, which is not good for the entire economy and industry. Some rethinking has to be done. Yes, there are people who are floating the system. There are people who are doing fraud, but they have to be dealt with separately. Normal taxpayers should not be affected. Another restriction they have brought now in the recent budget on ITC. I am a supplier, you are the recipient. Whatever I supply to you, you are eligible to take the credit. This is the law. Now they are bringing in some conditions. If as a supplier, I have committed some mistake, what are all the mistakes they have listed down? For example, there is a restriction saying that even though I have enough credit, I have to pay at least some amount of tax in cash. That is one reason. If I fail in that, so if I fail in, I will not make it too complicated. So what they have done now is, if the supplier is committing any mistake, then all the persons who are purchasing from him, they will not be able to take the credit. That is the level up to which they have made amendment in the last budget. So this is not good. Maybe forums like us, we have to take it. Yes, this is not that we are supporting the fraudsters or anything. We only want that a proper distinction has to be made. We should not go back to our olden period where the physical register was snatched away. We should not go for that. So technology has to be used more effectively. And another thing is, each business is different. Construction business is different. Running a supermarket is a different business. So law should take care of all the business practices. So this is one area which is bothering all of us, like this ITC, which is the backbone of GST, is unnecessarily being given lot of restrictions and controls. Whatever be the justification, this much of restriction should not be there. That is one fundamental point which I wanted to emphasize. Secondly, if you see, there is another power available to, another benefit of GST is all the checkposts have been removed. All the checkposts have been removed. We know that. Earlier, if a consignment has to go from Tamil Nadu to Kerala, in the Walayar checkpost, they have to stand for 1 full day or 2 days also. We don't know. Now all the checkposts have been removed, which is a great success of GST. But at the same time, earlier at least we know that there is a checkpost at Walayar. Today we don't know where is the checkpost. All through the route from Chennai to Palakkad, you will be stopped by the officers. You can be questioned. So what is happening is, even for procedural mistakes, if there is an evasion, no question at all, it has to be booked. If you see that section which deals with road patrol and all that, you catch hold of somebody, you see whether tax is paid or not. If tax is not paid, collect the tax. On the spot you collect the tax, on the spot you collect the penalty, then only you release the vehicle. This is a law. This law should be applied if somebody is evading. But what is happening today is, you have not put the comma. Chennai to Palakkad, the kilometer is 499, you have put 489. This is the route. You have to go through Erode, Salem and all. Why you have deviated to Perundurai? This is not your route. You may be aware, recently one case what happened in Andhra, there was a political agitation going on. So it was a small auto. He cannot enter that road. There was a protest against that Citizenship Amendment Act. He waited till 9 o'clock, nothing happening. So the auto driver took the vehicle to his house. Next day was a Sunday holiday for everybody. On Monday he took the vehicle and delivered the vehicle. For that, his vehicle was stopped, the assessee was asked to pay penalty, tax, everything, and the High Court found that the reason was genuine. The High Court imposed a 10,000 fine on the officer who stopped the vehicle. Department went in appeal to Supreme Court. Supreme Court has said, High Court has committed a mistake. They should not have put the 10,000 penalty. They should have put equal to the tax amount. So they enhanced the penalty to 69. So what I am saying is, whatever be the ideals of the legal provisions, at the field level, it is giving rise to lot of harassment. The provision is pakka. We don't dispute section 129, we don't dispute section 130. But the way in which it is being applied on the road by the field officers, that is creating problems, and that is one of the major problem which we have been undergoing recently. So secondly, another factor which is affecting GST today is, I'm just wondering, is there too much of bureaucratization in GST? So lot of things have been left to the bureaucrats. If you put the Control F in the GST Act, you will find the word prescribed 200 times. So in the manner to be prescribed, it will come 200 times. So lot of details have been left to the executive by way of notifications, circulars and all. In the last 4 years, more than 1,000 circulars have been issued. Every year, every month, there may be some 3-4 circulars. Nearly 2,000 notifications have been issued. So, too much of bureaucratization. I will give an example. There is something called a transitional credit. So, when we all moved from old tax to new tax, whatever credit we have taken under the old law, it should be carried forward to the GST law. Fundamental principle. Second, under the old law, I am not eligible to take some credit, but I am eligible to take that credit under the GST law. For that, there has to be a provision. So that is called transitional provisions. Lot of transitional provisions are available. If you read that particular section 140, it will be very, very difficult for a common man to understand each situation. Each subsection will deal with one particular case. It is a very complex provision. It is required. Because considering the complexities of our business, the law has to be, if anybody is saying, we will make the law simple, we do not believe them. So in our country, no law can be simple. So 140 is very complex. Many people have missed their deadline. Many times the government has extended the deadline also. And finally, they brought in a retrospective amendment. This retrospective amendment is another problem today what we are facing in GST. So how far, whether it is with the backing of the political leadership or is it happening at the bureaucratic level, because as we all know, the bunch of budget papers, how many MPs will be going through all those things we all know. So whether taking advantage of it, the bureaucracy is pushing this retrospective, because the Prime Minister said in one of the business meetings, retrospective amendments is the thing of the past. Neither this government nor any other government will do any retrospective amendment. This was the assurance given by the Prime Minister to the business community. What has happened in income tax? The infamous Vodafone retrospective amendment, they nullified. Courageously, they nullified the retrospective amendment on the one hand to promote the image of the country before the international forums. On the other hand, what is happening in GST? We don't know whether all these things are reaching the knowledge of finance minister, the political sector. We don't know, or it is all pushed through. So many retrospective amendments. On this transitional credit, the time limit is always procedural. May learned from department are also there, kindly bear with me. So time limit is procedural. We shall to give some extra, because understanding this law, technology, portal, all these are new. So there has to be a liberal approach. Once credit is eligible, just because it is time barred, he has not filed the return within the time, it should not be denied. That should have been the approach. But to bring a time limit, they are doing a retrospective amendment. Second, there was some confusion. See, my point is, indirect tax law. If the law is clear today, everybody will follow the law. If there is an ambiguity, 10 people will give 15 opinion, everybody will understand in their own way, and they will take their business decisions accordingly. One example, there was something called education cess under the old law. As we all know, cess is levied, the government, central government need not share it with the state government. That is why cesses are levied. It will be levied for a particular purpose. For educational purpose, they levied one educational cess. Then for secondary education, they levied a secondary education cess. No nursery cess, no college cess, only two. So we also know that thousands of crores collected as education cess were not used for education purpose. It is still lying in the books, and CAG has raised the objection also. So once the GST is introduced, what will happen to the education cess? Whether that credit can be taken or not, that was the issue. There is no answer in the law. It was open. So there is one famous saying which I always used to say, what is not prohibited is always permitted. So if there is no specific prohibition, it means nothing is permitted. So all the people have taken the credit of education cess. After 2-3 years, a retrospective amendment. The problem in indirect taxation is, once I think that I am eligible to take the credit, legally, I am not floating the law. The law does not prohibit, we take the credit. We take the business decision accordingly. I fix my price accordingly. It's a competitive world. And after 3-4 years, if you are going to come back and retrospectively amend means, that is upsetting the business. That is the problem in indirect taxation. At least in direct taxation, it is my pocket. Whether I pay today or tomorrow, it is all going to be from my pocket. Whereas in indirect tax, it is not so. So this is one particular area where these retrospective amendments are another area where today's GST is being affected. So as a principle, there are some critics of GST who may say that, what is this? In Singapore, there is only one GST. Here you call it CGST, SGST, IGST, compensation cess. And in Singapore, it is only 7%. Here you have 5%, 12%, 18%. I don't support that view. For the simple reason that our country is not Singapore. For the disparities what we have, for the political compulsions we have, it is definitely impossible to have a single rate or single GST in our country. At least for next 15 years it is not possible. So this is a step which we have taken. This is the first step. Maybe going forward, after 10 years or 15 years, we can also have a single GST. We can also have a single GST, but today it is not possible. So that is not our grievance. The grievance is these uncertainties. People are bound to commit mistake. Even while making the law, when I was telling about this education cess, to say that education cess credit is not allowed, they made a retrospective amendment. While making the retrospective amendment, they committed a mistake. To suppress that mistake, that particular amendment has not been notified at all till now. This is where I believe the role of the bureaucracy. No parliamentarian or no finance minister would have gone through these details. So the mistake committed in drafting the law, the mistake committed is suppressed by not notifying that provision even today. Even after 2-3 years, they have not notified that at all. So this is where I suspect that the role of bureaucracy is more and more in GST, which is not good. And we have to salute the GST Council, which is comprising of the finance minister. So it will be 220. So all the in our country, politically we are divided, socially we are divided, but at least on one front we are united, that is the GST. Enormous cooperation. All the 45 meetings so far, unanimous decisions, fruitful discussion. Everything is happening, which is a very good sign. So in a longer run, GST will be definitely good for our country. During the initial period, we are facing all these problems, but over the period, it has to settle down. But as our role, the judiciary and we, the bar, we have the biggest responsibility. This is a new law. This is a complex law. And Madras state, that is the Tamil Nadu state, is a pioneer in taxation. Even today, one of the famous tax judgment is Gannan Dankarli, which is started from state of Madras in 1950s. Even till today, we are talking about that judgment. So, in development of proper GST jurisprudence, the role of bar and bench is very important. So that is where all of us have to be aware about all these provisions properly. What is the basic principles behind the GST? We may win cases, we may lose cases. That's a different issue. But at the end of the day, all of us have to strive that this tax jurisprudence is improved. And the Madras bar has got the role in, because we have got started from Natarajan sir. His contribution for the VAT development is immense, the sales tax. So like that, I hope that this Madras bar and Madras judiciary also will be a pioneer in developing the GST jurisprudence. I thought I will mention about 1 or 2 Supreme Court judgments which are very important. We don't have time, I think. And maybe I will address this advocate issue now. See, advocates, fortunately or unfortunately, most of the finance ministers are also advocates. So anybody say that you should not put tax on me, no finance minister will listen. But they have listened only in 2 cases. On transportation, when they levied service tax, they said we will go on strike. So if we go on strike, nobody will be worried. Or if any other sector goes on strike also, people will not be worried. But transport sector goes for strike, it will be a difficulty. So they said, no, you need not pay, your customer will pay. The transport agency need not pay the tax, the customer will pay. It is called a reverse charge. So similarly, when advocates service tax was imposed in 2009, subsequently in 2012, it was shifted to the recipient. So when we provide a service to a business entity, then we will raise our bill, they will pay the GST directly to government. When we provide service to individuals in a family dispute, property dispute, GST is exempted. So in any case, GST is not applicable in the hands of law firms and individual lawyers or senior advocates, anybody. Many of us might have received a lot of letters from the department. There is a difference between your income tax return and ST3 return. What is the reason? So none of us have to worry about it. This is a technology. Sometimes technology is good, sometimes technology is bad also. Today everything can be compared. So this is one particular tool developed by the department. Based on our PAN number, they will compare the income tax return and service tax return, if any. So if no service tax return is filed, simply they will send letters. Thousands and thousands of letters have been sent like that to doctors, advocates and all that. We need not panic about those letters and all. There is no change in the position of law. Simply give a reply, I am an advocate, I am not liable to pay the tax. Well, then they will close the issue, because our income tax return will not show that it is an advocate income. Income tax return, it will be a business income. What business we are doing, the department will not be able to know. So mechanically these type of notices might have been issued. Nothing to worry on that. In fact, in some cases, Delhi High Court and all, against that letter they went to High Court. High Court has granted a stay and all that. I feel that even that reaction is not required. This is a routine exercise which is done by the department by mere comparison of GST return. Yes, sir.
Is there any notification? Is there any notification? Is there any notification?
Yes, I'll tell.
Just share that copy.
I'll tell, yes. Yes, sir.
I can go.
Yes, up to 20 lakhs there is a basic exemption. Whatever business I do, if my income tax return turnover is below 20 lakhs, I will not issue notice. If it is more than 20, and I think being members of MBA, all of us will be more than 20 lakhs, I think. Now, there are two notifications. One, 12/2017 Central Tax. 12/2000, I will share through your office bearers also. That will tell about the exemption available when you are providing service to individuals and small business entities. So that is an exemption notification. There is another notification, 13/2017, which will say the advocates are not liable to pay and the firms are not liable to pay. It is only the recipient who is liable to pay. So these two notifications are important. I will share with you the relevant, because if you see that notification, it will run for 120 pages. So what is the relevant entry? I will just take it out and share with MD. Sir? 12 and 13 of 2017 are the relevant notifications. Now, one important development. Shall I continue or yes? Okay, continue. If anybody has to reach the code, maybe another. Any questions, please? No, I have a request for him. This 40 minutes is not sufficient. So we will invite Mr. Natarajan for one more day for part 2 lecture. Are you all agreeable? Yes. Part 2. Because it is a wide subject. Vast subject. I invite Mr. Chandrakantan, former treasurer, to present a shawl to Mr. Natarajan. You will come. Secretary will propose vote of thanks. Please go. Respected President, my dear members, it was really a very informative lecture today.
And as President rightly informed, this is only the first of the part 1 of the series of lectures which our guest speaker will be delivering. Sir, thank you very much, sir. This is the first time we are listening to you, and we are really mastering this subject. Thank you, because many of us are only, in the primary class as far as this subject is concerned. Thank you very much. Probably we are in the play school. Yes. Thank you very much, sir. Let us listen. Yeah, it was very informative, and it's so that a colloquial man can get the bird's view of the subject. Thank you, sir. Thank you very much. I thank all the members, and my special thanks to Mr. Arvind Ghosh, who was some technical improvement. He has organized the live relay in YouTube. So today more members are benefited by watching it on YouTube. Thank you, sir. Thank you. Thank you. Thank you, sir. Mr. Sir. Thank you.